You brought a lawsuit against your doctor for medical malpractice, and now, during the course of your lawsuit, the defense actually makes an offer to settle your case. You immediately reject it and are insulted with the amount that they gave you. Your case goes all the way to trial, and now the jury gives you much less than what you originally were offered. Can you go back to the defense and see if they're willing to increase their offer to go ahead and go back to what they originally offered? You want to know the answer? Come join me for a moment as I share with you some terrific information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And the answer is not a chance. Once the jury has reached a verdict, they have now said, hey, listen, this is how much money we feel you are entitled to be compensated for all of the harms and losses and damages that you incurred because of your doctor's carelessness. They evaluated and came to the conclusion that yes, your doctor was in fact careless, that he violated the basic standards of medical care. And yes, the jury also determined that his carelessness was a cause of your injury. And then the jury went ahead to evaluate the value of your particular damages, the injuries that you suffered as a result of this carelessness. And maybe you had pain and suffering from the time of the event up until the time of trial. Maybe you had pain and the suffering that you incurred from the time of the trial into the foreseeable future. And maybe you had other types of damages as well. But when the jury comes back with the verdict, totaling how much money you are actually to receive for each element of damages that you incurred, now it turns out that it is much less, much less than what the defense originally offered to you that you rejected immediately. Now you want to go back to the defense attorney and say, hey, we're willing to take what you offered. Will they do that? The answer is no, they won't. Why should they? Why would they? There's no rational reason why they would do that. Now, there is one possibility that may occur. You may have grounds to appeal the case. You may have grounds to say, from a legal standpoint, hey, listen, this jury verdict is inconsistent with the evidence. It's inconsistent because of all the testimony that we presented, because of all the medical experts that came in that explained how your injuries are going to be permanent and significant. The jury heard testimony about how disabled you are and how you're unable to return to work. And now, based upon that information, your attorney could argue, certainly to the trial judge, Judge, we believe that this verdict is inconsistent with the weight of the evidence and ask that you throw out the damages portion of this trial. And we ask that you set this matter down for a new trial so that now the jury can really evaluate the value of this patient's injuries. And then, if that doesn't work, your attorney might be able to try and appeal the case, again, assuming that there are specific legal issues that he believes were incorrectly ruled upon, such as evidence or certain testimony that came in, or certain rulings that the judge made might be incorrect, that might have altered the outcome and altered their perception of what they could and could not give you for your damages. That is a possibility. And in that instance, the defense could possibly turn around and say, you know what, we don't want to go through the entire appeals process and run the risk that we're going to lose and then have to go through another trial all over again. In that instance, they may come back and say, you know what, we are willing to negotiate. And now you can have a conversation about how much your case really is worth and what it's worth to try and stop it right now rather than go through the entire appeals process and run the risk of not knowing what the ultimate outcome will be. But in all likelihood, now that you go back to the defense attorney after the jury has come back with their verdict, after they have come back and made a determination about how much you are to receive, the defense is not going to turn around and say, yeah, sure, we'll give you much more than what the jury said your case is worth. You took the risk, injured patient. You and your attorney took the risk that we would go to trial and that a jury would come back with a huge verdict, a very significant verdict, much more than what we originally offered to you. And that was a risk you accepted. Well, guess what? When you go to trial and a jury comes back with a verdict, you don't know what the result is going to be. Your attorney doesn't know what the result is going to be. The defense lawyer doesn't know what's going to happen. The defense's insurance company doesn't know what's going to happen. The judge has no idea how the jury's going to rule. So you have all of these unknowns. And a settlement happens to be a guaranteed amount of money, but you turned it down. And that's perfectly within your right, because now you wanted to take what was behind door number 2, and that was the jury verdict. And now you have to live with that. And if you can't live with that, now you have to try another alternative to see if somehow your attorney can try and get that portion of the verdict thrown out, or possibly appeal that portion of the verdict, and now let the higher court, the appellate court, make a decision about whether or not there really were legal issues that were incorrectly decided upon that actually altered the outcome of your trial. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in the litigation process. Now, once the defense has actually made you a significant offer, you reject it, the jury comes back with their verdict, and now you want to go back in time and say, yeah, you know what, give me the money, I'll take the money right now. That's not going to happen. You know, I do realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit, but are thinking about bringing one, and still have questions, what I encourage you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.